right. Good morning, everyone. Thank you so much for joining us today in the National Press Theatre. My name is Amanda Connolly. I'll be moderating today's press conference. Joining us today is the Right Honourable Richard Wagner, Chief Justice of Canada. We will have a brief statement from our guest today, and then we'll open it up to questions. We have a hard stop at 10:30, so we'll fit in as many folks as we can today. If I haven't already taken your name, just raise your hand, and I'll get everyone on the list for today. Perfect, and with that, I'll hand it over to our guest.
All right, thank you so much. Bonjour à tous.
Good morning, everyone, and thank you for taking a bit of time out of your day, especially such a nice day outside, to come here today. It will be almost 6 months since I took office as Supreme Court Chief Justice, and I thought that it would be quite appropriate to follow up on a suggestion of Christian Schmidt and to have a bit of a dialogue with you and to talk to Canadians about the state and the work of the Supreme Court and the initiatives that we're taking to improve communication with Canadians and to ensure that the Supreme Court remains relevant and effective and credible with Canadians, so that we can carry out our mission of interpreting the law and applying the Canadian Charter of Rights and Freedoms.
Let me first say a few words about the place our courts play in our democracy. Canada's Constitution consists of three distinct branches of government: the legislative branch, meaning Parliament and the provincial legislatures; the executive branch, made up of the federal and provincial governments and the civil service; and also the judicial branch, consisting of courts throughout the country with the Supreme Court of Canada. The judiciary's role is to interpret and apply the law. This is a major responsibility. The ability of citizens and governments to resolve disputes fairly, efficiently, and peacefully by resort to independent and impartial courts is the hallmark of a society governed by the rule of law. Toutes les sociétés ont des règlements.
All societies have regulations and laws that govern them, but the luckiest among them are the societies that have the rule of law. This is the principle that laws apply to all citizens, whether they have power, whether they are powerful businessmen, or whether they are more vulnerable citizens. And in fact, even non-citizens seeking security are subject to the rule of law. So that is the difference between a free society, a free and democratic society such as ours, and despotism or dictatorship, where there is a lack of respect for institutions, a lack of respect for the rule of law, a lack of respect for judicial independence, and a lack of respect for freedom of expression and the media.
That the courts are there for them when they need them. The public also has the right to know how our courts work. The Supreme Court of Canada has long prided itself on being an open and transparent institution. Canadians have always been free, indeed welcome, to attend our hearings and read our decisions. The same is true for courts across the country. But what we mean by open courts is different in 2018 than it was even 15 years ago. New technologies create new ways of being open. New circumstances require new approaches. In March of this year, we began publishing plain language summaries of our decisions, called Cases in Brief, ou Causes en Bref, on our new Facebook page, our Twitter account, and our website. We tried to draft these summaries to be short and easy to read, but still faithful to the court's judgments. Cases in Brief are a great way for Canadians to learn about the court's decisions. Journalists and the media who cover the court also find these summaries helpful. I am pleased about that, because supporting the media in its coverage has been a responsibility of the Chief Justice through his or her executive legal officer for over 30 years, and that will continue. Another initiative we are now working on is an accessible, thorough annual report of the court's operations. At present, the court releases a lot of information in a lot of places, following various government policies that apply to the court's registrar and staff. We are now working with the government to streamline these policies and requirements so that we can produce a modern, accessible annual report of the court's activities. Judges of the court often have occasion to meet the public at events around the country. We welcome those opportunities. I am pleased to announce that next year, the entire court will visit Winnipeg for meetings with Canada's appeal court judges. While we are there, I look forward to other meetings with local lawyers, law schools, and community members. I look forward to visits by the court to other Canadian cities in years to come. What I would love, in fact, is for the court to sit and hear cases in other Canadian cities from time to time. I think it would be a wonderful thing for the court and the public. How we bring the court closer to Canadians is something I think about a lot. Mes premiers mois en tant que juge en chef ont été
My first months in office have been busy, to say the least. Before June 15th, the court had tabled all of the rulings that my predecessor had participated in. And we managed to do that. So I feel very privileged to be in this very stimulating position and to have the unfailing support of each and every one of my colleagues and staff. And of course, the staff are among some of the best in the public service. Thank you so much for your attention.
Take your questions.
Great. All right. So again, we do have a hard stop at 10:30, so we'll keep it to one question, one follow-up. Our first question goes to Philippe Vincent Foisy from Radio-Canada.
Bonjour, M. Wagner.
Bonjour.
Président de la presse de la semaine.
Good morning. Thank you for being here. Thank you as well. Inaudible for the interpreter. Interpretation service will resume once the sound quality permits.
Comment la Cour voit son rôle dans la défense des intérêts des provinces, du gouvernement fédéral? Les gens sont peut-être mélangés, là, beaucoup de dossiers vont se rendre chez vous. La Cour, de façon vulgarisée, ça va trancher comment dans cette bataille?
La Cour a toujours été appelée à...
Well, in the past, the court always ruled on files that required its attention, and the court will continue to do that in the same way. In other words, we don't work in the political sphere, we work in the legal sphere, and there are people who much more qualified than us to talk about provincial territorial relations on various issues. Now, when we are called to rule on a question, we apply the law. So in disputes between provinces and the federal government, of course, there is the question of jurisdiction, which is in the Constitution, and sometimes the Charter comes into play as well. So we apply the law based on the evidence that we are presented with, and we leave the rest to other stakeholders. Interpretation service will resume once sound quality permits.
Qui n'existait pas à l'époque, là, c'était pas quelque chose qui était particulier. L'environnement n'est pas une compétence non plus très ferme, que ce soit provincial ou fédéral. Comment on peut prendre un document si âgé et l'appliquer aujourd'hui à des situations auxquelles les auteurs de la Constitution n'ont pas pensé?
Ouais. Ben ça, c'est un vieux principe.
Well, that's a very old principle. I think that the court has always believed, and I believe firmly, that the Constitution is like a tree that grows. So we need to interpret it as it grows and evolves, as society evolves. And, of course, new technology can take us to new places. And we need to interpret a text in the way that we would interpret something that is evolving.
Hello, Chief Justice. I wanted to ask you about some retired Supreme Court judges and historians
have been critical of the 50-year waiting period for the court's transfer agreement with the Library and Archives Canada, describing it as decades too long. I'm wondering, why did the Supreme Court choose 50 years as the appropriate period of time for an embargo on its materials?
Well, I'm pleased to answer that question because we have to put it in context. My predecessor a few years ago, with the support of all the colleagues, decided that it may be a good idea to keep our records, to keep the notes, to keep the draft memo, the notes that would accompany the final decision, because before that, there were no policies. So the documents were destroyed. And we thought that maybe it would be a good idea eventually to keep a record of those documents. And in many countries in the world, there are no such policies. So that's why the first attempts were made with Archives Canada to have some kind of agreement according to which those records would be kept eventually. Now, the question is, in certain country like, for instance, the Netherlands, the records will be kept for 75 years. In France, there's no record. And it would be, of course, a crime for a judge to discuss even what was discussed during the deliberation before judgment. Same thing in Belgium. It would be a crime to disclose any documents and information. So in Canada, we took the position that we should keep it, but we should keep it also in line with the protection of another important principle in Canadian law, that is the deliberative secrecy, which is part of our law in Canada, so that a judge could never disclose or discuss in public the reasons why he would go one way compared to another way, to discuss why he changed his mind or that type of thing, because we want to protect the integrity of the process of releasing judgments. That's for the public interest. So we had to deal with that problem, and it was decided that 50 years was a good period to, at the same time, protect those documents which were destroyed before, and at the same time protect also the deliberative secrecy. And that 50 years, we thought that we have precedents that will last at least 50 years, and so that was a good period to make sure that this main and important principle be protected. So we were very proud of that agreement.
Did you consult with any historians outside of the court on the timeline, and how does it square with the commitment to transparency and accountability, seeing as Americans, for instance, have access to this material much sooner? I
don't know about the Americans, and I would prefer to follow the Canadian way of doing things. But I think it's in line with this transparency concern. Because before that, there were no documents. Now we'll keep it. We'll keep a record.
Okay, our next question goes to Deborah Giapon from the Canadian Catholic News.
And yes, Mr.
Yes, good morning.
Justice, thank you. After the Trinity Western decision last Friday, the former Ambassador of Religious Freedom for Canada, Andrew Bennett, said that the court had effectively relegated religious freedom and conscience rights out of Section 2 of the Charter. How do you respond to that criticism, which was shared by many religious leaders after the decision?
Well, any decisions that we release dealing with the rights, with the Charter rights, will bring all kinds of reaction, and it's normal, and it's good in a way, because it shows that the court has decided an important issue. I will not respond to those comments. In that decision, the majority, and you know that I was part of the majority, I wrote part of that decision, and we are very comfortable with our reasons, and it's up to the public and the citizens of this country to interpret or consider that decision as they want.
Today is the feast of St. Thomas More, the patron saint of lawyers, and as you know, he died because he obeyed his conscience rather than the King Henry VIII. And conscience rights, it seemed from the decision that they were, and religious freedom, less important than the identity of LGBT people, that somehow one's religious identity could be set aside at least for certain purposes outside of the walls of religion. Is that an improper reading of the decision?
That's one interpretation, and I respect it.
Okay, our next question goes to Tonda McCharles from the Toronto Star.
Good morning, sir. Can you speak about how you see the role of dissenters on your court and what you see your role as in terms of crafting consensus versus allowing robust dissent?
Well, in Canada, I think that dissenting reasons is part of our DNA in a way. It's very much linked to the common law jurisdiction. In Europe and in civil law jurisdiction, you will very often you will never see dissent. In France, for instance, Conseil d'État, or in Belgium, there is one decision. That doesn't mean that they all agree. They have disagreements, and I know that for a fact, but they will not show it, and it will be behind closed door. And there will be one decision of the majority, which will be the law. So that's one way to look at it. It's very typical of the civil law jurisdiction. In the common law jurisdiction, and in Canada we have both civil and common law, it's different, and I would say it's more transparent. I like dissent. I think it's good. And I would be very worried if we were always unanimous on a case. I mean, I would be worried. That doesn't mean that unanimity is not good, but I think it's normal that in society like ours, open society, with the Charter of Rights, with our type of democracy, I think it's normal that you will find dissenting judges on a court case. And I think it's good. That's one thing that will stay. And as long as the dissent is made and is released in order to explain with civility a legal position, I think it's a good thing.
Could you speak about how you see the court's role in terms of some of the big questions that face the country? Do you think it's the court's role to take a lead on some of the big questions, such as reconciliation, some of the divisive social issues, where Parliament has perhaps not moved as quickly as public opinion? Or do you feel it's the court's role to wait until public opinion comes to some consensus? What do you see the court's role is? Do you have a nation-building role? Do you have a leadership role? How do you see that?
Well, I think that we essentially we have to decide cases that will be brought to our attention. But that being said, I think that the Supreme Court and the Chief Justice in particular, I think we have an obligation also to speak to the people and to make sure that the people of Canada keep their faith in the judicial system. And that could be made by our presence, by our speeches. And right now, we see outside Canada that some of our basic values, fundamental values, and moral values are seriously attacked by other countries, leaders of other countries, who pretend to be democratic. And I'm talking about democracy. I'm talking about the rule of law. I'm talking about respect for institutions, and that makes me concerned, because I think we have to be very careful. And in those circumstances, I believe that Canada, and when I say Canada, I mean the Canadian institutions, have a role to play, not only inside Canada, but also outside the country. And, we're not a superpower, economically speaking. We're not a superpower in military terms, but we are a power in terms of the rule of law, in terms of the moral values. And I think that we should build on that and say it. And there are people outside the country that are looking to us to get our support, because they need our support, because we can't speak on behalf of Canadians for those values.
Okay, Michelle Lamarche with TVA.
Monsieur Wagner, si
Interpretation service will resume once sound quality permits.
pouvait devant la Cour suprême et qu'il y a une partie des Québécois qui se disent on sait comment ça va finir. De toute manière, la Cour suprême du Canada penche toujours du même côté, du côté du gouvernement fédéral. Qu'est-ce que vous leur diriez aujourd'hui?
Est-ce que ça se dit encore, ça?
Is that still being said? I haven't heard that recently, but I take you at your word. Well, I'm just going to wait for the case to come before the court, and then, based on the evidence that is presented to us, we'll make a decision. If there is a reason to intervene, then we will, but the Supreme Court does not lean one way or another. I am convinced that the members of the court who are there do their work very professionally, that they are dedicated to providing the best moral, professional decision possible based on the evidence that they see. I'm really convinced of that. Interpretation service will resume.
Et on avait senti que pour essayer de calmer la crise, la Cour avait décidé de pencher dans une certaine direction vu la situation constitutionnelle dans laquelle on se trouvait. C'est pas un exemple, ça, du rôle que la Cour doit jouer pour aider le gouvernement fédéral?
Je peux pas témoigner.
Well, I can't comment on what my predecessor said or thought. I wasn't there. But what I can say is that what I would do and what my colleagues would do in a delicate case like this, which has to do with jurisdiction, competing jurisdictions, or cases where there may be a constitutional clash in terms of jurisdiction, the court, by its very nature, would look at the testimony presented, and certainly there's no preordained agenda.
Van Dusen, CBC News.
Bonjour. Sir, I'd like to ask you a similar question in English about, as you know, marijuana's passed. We're anticipating challenges on the 4 plants and on random testing. Have you read C-45 and C-46?
I've read what I could read, but I will wait to see if there's a challenge to determine whether we have to intervene.
That's what I thought you'd say. That's why I'm not going to ask you about pipelines. But
Good reaction.
But I would like to ask you, you obviously are interested in opening up the court. You talk about traveling. You talk about, it's great you're having this news conference. Most Canadians involved with the law are never going to be at the Supreme Court. Why do you think it's so important?
Well, that's because exactly the reason you just expressed is that most of the people will not come to Ottawa to see how the court works. And what we are noticing is that more and more Canadian people will take their news from the social media. As a matter of fact, 45%, I think, of the Canadian population will take their news from the social media, which places Canada behind South Korea in second place. So that means something. And that means that also the traditional media that you represent, because of underfunding, because you don't have anymore, unfortunately, all the resources needed to do your work, you cannot necessarily report everything about the court's decision. So while we're still supporting the traditional media, and we do it at the court for many years now, we try to find other ways to communicate directly with the population. And one way, of course, we've got Facebook, we've got Twitter, we've got the cases in brief now, and one way is to take the opportunity to talk directly with the citizens, and take, for instance, this opportunity today to go and visit people locally, like we'll do in Winnipeg in 2019. And the idea is to make sure that people understand who we are, what we do, how we do it, and why we do it. Because ignorance is the cause of many bias. And the more people will know about the judicial system, the more they will keep faith in the system. And that's very important, given the environment in which we live outside Canada.
Okay, just a reminder, we've only got about 5 minutes left, so we're hoping to get to everyone, but we'll go to Jim Bronsko from the Canadian Press.
On openness, you've mentioned some of the things your court is doing. Are provincial courts across the country following suit? It's still very difficult to get court records. It can be expensive. Very little material is digitized or made available online like you've done. Can provincial courts be doing more?
Well, I think you referred to the notion of access to justice in a way, whether it be a provincial court or a superior court. And what I said many times is that the justice system, of course, has been the parent pauvre of society for many, many years now, at least for 50 years. And not only in Canada, but also outside Canada, in other democratic countries, because all the funding, all the investments were made for health and education, which is great. But as a consequence, of course, the justice system did not get enough investment. And one of the problems is exactly the consequence that you referred to. That is difficulty, under-finance, and not enough judicial resources, and access to justice, which is in jeopardy. I understand that following the release of our decision in Jordan a couple of years ago, I understand that government decided to invest in the judicial system. It remains to be seen whether it will be enough, but that's a big portion of the improvement. The other portion of the improvement is for the courts to try to find new ways within their jurisdiction to improve the access to justice in terms of rules of practice, for instance, and to try to keep it as simple as possible. You have to realize that even at the Supreme Court of Canada, 30% to 36% of all our motion for leave to appeal, and we've got between 500 and 600 per year, are filed by persons acting on their own behalf, self-rep, not represented by attorneys. So that means that these persons not only don't have the financial means, but some of them have the financial means, but don't necessarily have trust in the legal system to hire a lawyer. So that's very significant for me. So we have to facilitate the access to justice, and I think that all the stakeholders in society, the government with investment, the court with their rules of practice, but also the bar and the lawyers, I think that they should, I think we said that in Jordan and Cody, they should change their way to handle cases so that everybody will play the game all together. I'm optimistic.
Again, on openness, in the last election, the Liberal government, Liberals promised access to information that would cover your court and federal courts, so that Canadians could make access to information requests about, not about your judgments, but about, and deliberations, but about the administrative functions of the court, spending and such. What we're getting under the bill that's going through Parliament is something less. It's regular disclosure of expenses and things. What are your thoughts on how open the courts should be under access to information?
Well, I think that it would be premature for me to comment on the bill, which is not yet adopted, to my knowledge. So we'll wait to see how it goes. My only comment for the moment is that, of course, I'm all for transparency. I think that we should be transparent in everything we say, we do. I think that the world has changed, and the judiciary should follow. But at the same time, we have to be very careful also to protect, for the benefit of the public, to protect the judicial independence, so that through this disclosure process, we could not attack this independence as a consequence. Of any legislation. But I'll wait to see the formal legislation, so for me it's premature to say more at this time.
All right, unfortunately it looks like we only have time for one more question. Goes to Manon Cornelier with Le Devoir.
Oui, j'aurais un peu l'idée que vous
Interpretation services will resume once sound quality permits.
la façon dont on gère, vous pouvez juger à la Cour des questions d'un litige de juridiction, par exemple, et qui n'est pas défini clairement dans la Constitution, dans le renvoi sur la séparation du Québec. La Cour a émis, en tout cas, a verbalisé les principes non écrits de la Constitution. Donc, oui, vous appuyez sur la Constitution, vous appuyez sur la Charte, mais jusqu'où vous pouvez aller, justement, dans élargir pratiquement un peu la portée de certains articles avec des principes non écrits, tout ça, parce que, bon, il y a des causes qui s'en viennent, je ne vous demande pas de vous prononcer sur ces causes-là, mais comment vous faites pour trancher quand la ligne entre le fédéral et le provincial n'est pas claire?
Mais c'est pas facile.
Well, it's not easy, but we need to take a number of things into consideration. Of course, the text of the law itself, then the testimony and the way in which both parties presented their cases. And then there's also the broader context. So interpretation really means looking at the context. And when you're talking about something that happened several years after a text is presented, as is often the case, well, there are various interpretation principles. I talked earlier about the living tree. I don't think that we should have a strict interpretation of the meaning of words that were written, say, 150 years ago. But we need to look at those texts as though they're evolving with society. They are evolving with the moral values and expectations of society. So the context at the time that the court makes its ruling is very important. For example, you could take the Carter case about assisted suicide. Several years before, with looking at the same facts, the same evidence, the same provisions of the criminal code, we came to a different decision. But this time it was unanimous. And yet it's the same provision. So there is a contextual interpretation that is independent of the evidence that's heard. And that's a function of society's evolution and also the evolution of technology, medicine, and moral values that unite Canadians. So that's an example of a decision that takes the context into consideration. And the same thing happens with constitutional interpretation. If you interpret a text that was written in 1867, for example, it's the same idea. Interpretation service will resume when sound quality permits.
La Constitution 82, et c'est la question de l'environnement. Alors, est-ce qu'il y a comment vous gérez, où là, il y a une évolution rapide des mentalités, vous gérez comment un dossier d'environnement est un enjeu de plus en plus chaud dans la société. On l'a vu dans les questions autochtones, il y a eu l'interprétation. Qu'est-ce qu'on fait au niveau de l'environnement? Est-ce qu'on a déjà certaines pistes avec lesquelles on envisage l'enjeu de façon plus globale?
Mais moi, je compte beaucoup.
Well, the contribution of the lawyers on either side and the evidence that they present is very important to me. Whether it's at the appeal court level or the Supreme Court, we depend on the evidence that is presented. Now, I understand that there is interpretation that flows from that evidence, but you need a robust interpretation that is based on the effort of people who intervene. So it depends on the question, but if we're talking about the environment, the stakeholders could be government, environmental lobby groups, any individual or organization that might have an interest to defend or claim or a position to defend when it comes to the environment.
And for
Oui? OK.
Interpretation service will resume once sound quality permits.
50 ans, dans un système de justice pénale qui est axé sur la réhabilitation.
Vous avez raison de dire que
Well, you're right in saying that our correctional service is based on rehabilitation, and I think that's a good thing. Now, I've already spoken in the past about sentences, notably in the case of Norbourg and Mr. Lacroix. And I commented on some sentences that were handed down in other jurisdictions outside of Canada. Since making those remarks, there has been a change to the criminal code, to the legislation, that would allow the court to impose sentences in certain situations that previously might have gone past the usual limits. I think this provision has already been challenged, and I won't make any other further comments on that at this point.
Fantastic. And I believe that's all the time that we have
It's
for
too
today.
bad that Kristen Schmidt could not ask a question because I said earlier that the reason why
Absolutely. If you're able to take more questions, we're happy to have you.
the reason we're here today.
Yeah.
The reason we're here today is because your suggestion, the last meeting we had.
Thank you, Chief Justice. I want to focus on the Canadian Judicial Council and how that you're the head of it and how that features into your belief in transparency. And I wanted to know concretely what you will do to make that a more open body. It is the Council of Chief Justices in the country. It makes policy suggestions, at least, and it actually makes policy for the federal courts across the country. It meets twice a year on the public dime. We never know the agenda. We rarely know the outcome. What are you going to do to make it more transparent? And then as part of that, why should the Chief Justices not have to disclose their expenses, their travel expenses? Because under this bill that's going through, even though judges will have to disclose expenses, there's an exemption for Chief Justices on the Canadian Judicial Council for the travel they do.
On the last portion, I will wait to see the bill. And for the moment, I think it would be premature for me to comment on that. On the rest, I think you're right, Kristen. I think that the CJC is a very important body. And you know that it deals with legal education. It deals also with disciplinary conduct. And I already expressed my view to the Prime Minister and to the Minister of Justice that reforms are needed. And more particularly with respect to the judicial conduct process. It does not happen often, hopefully, but one is too many. And when it happens, when there is a complaint against a judge, it should be processed rapidly. It now is much too long, it's too costly, and you could find yourself with a judge not sitting for years, not knowing what will happen to this individual, and the people not knowing, not having a judge available to sit in one district, and it's costing a lot of money. So it doesn't make any sense. So we have to reform that process, even if it does not happen, hopefully, too often.
But apropos of that, the Judicial Council has been asking for reforms, discipline reforms. Meanwhile, on February 22nd, the Judicial Council recommended to the Minister of Justice, to this government, to remove Justice Girouard. He doesn't have the integrity to sit on the bench, according to this Council of Chief Justices. So the judicial branch says he shouldn't be on the bench anymore. The government has done nothing. What about that? Is the process working? There's a recommendation to remove this judge, but I've asked them repeatedly what they're going to do about it. They say in due course. Well, meanwhile, all those people in Abitibi-Témiscamingue don't have a judge.
Yeah.
Is that satisfactory?
It's not satisfactory, and we made it very clear. And that's why it has to be changed. And, when I cannot comment specifically on this individual, you will understand why. But it goes to show to what extent doesn't make any sense that to use your example. There's a judge who doesn't sit for many, many years. And I understand that the Judicial Council, I think it's 21 members, chief justices across the nation came to a conclusion. So I think that I would ask the question once again to the person responsible. But I know for a fact that when I raised this problem with the Justice Minister, she was very sensitive to the issue. So I'm still looking for reforms.
Is it satisfactory that there's litigation going on in the federal court, which could go on for years, could go up to the Supreme Court of Canada, challenging this whole process? Is that satisfactory?
No. I cannot comment on those proceedings, considering the nature of the proceedings and that it may come up to the Supreme Court. But I think on the scheme, I think that you're absolutely right that it has to be reformed. And you gave the right example. So I'm still optimistic. We're working on that. We keep the pressure, and we hope that reforms will be made.
Chief Justice, will you take up Indigenous question? I know you have to go. I know we're over time, but it's such a vital issue.
One last question, maybe?
We're here for you. If you're able to stay, then absolutely, yeah. We're working with the schedule that you guys have told us. If you're able to stay, absolutely.
One more question.
Thank you, Chief Justice. I'm just curious how you see the role of the Supreme Court with correcting the disproportionate rate of Indigenous people who are incarcerated. We saw the recent ruling on the tests, but we also know that Gladue rights are not really being implemented in the way that they should be, especially in a place like Manitoba.
That's a terrible situation, I must say. And the number of Indigenous people incarcerated, the portion compared to the non-Indigenous people incarcerated is unacceptable. I mean, the rate is too high. It reveals a serious problem. And insofar as the judiciary is concerned, I'm not concerned about the politics. I'll leave that to other people. But insofar as the judiciary is concerned, I think that the court has a role to play whenever the case is presented to the court to decide those issues. We did it in the case of Ewart, like you mentioned last week. I think the decision was released, where we noticed that the tools used by the correctional services were not appropriate for Indigenous people incarcerated. So that we did not hesitate to denounce that situation and declare the whole thing in our judgment. So we can make our part. We are in a process of reconciliation. It's going to be a long process. It has to be done. It has to be done the right way. And it involves many stakeholders. It involves the government, of course. It involves also the various services and the court. And we are committed to do it within our own jurisdiction.
Great. All right.
Thank you.
We have about 5 people left on the list. If we have time, happy to accommodate all of those, but that's up to our guests.
You're not going to go for a long time. Come on.
Unless you want to come back once a week.
All right. 5 minutes. Let's get 5 minutes.
I'd like to just pick up on. Can we take the moderator's list, please?
Yeah. So we've got the next list up here is Leslie McKinnon, freelance.
Chief Justice.
Hi, Leslie.
I think I'll ask you something completely different. When the former Chief Justice retired, a lot of people asked me who would replace her, and I guessed you, actually. But a lot of people, a surprising amount of people, including members of the press, thought that you could never be appointed because you were appointed by a conservative government to the court. That obviously didn't happen. Can you talk at all about that process?
Well, it goes to show to what extent we are so lucky to be in Canada. And we have an independent judiciary. The same happened to Chief Justice McLaughlin as well. She was appointed by 2 different regimes, if you want, and the same happened with Lamère as a Chief Justice. So it goes to show to what extent in Canada, and I truly believe that we have judicial independence, but we have to work for it. We have to fight for it every time. But governments respect that, and our government respected that. And I was appointed to the Superior Court in 2004 by a liberal government. Erwin Cutler was the Minister of Justice. Paul Martin was the Prime Minister. I was appointed to the Supreme Court by a conservative government, and Chief Justice by a liberal government. So I rest my case.
And can I just ask, because I heard this once at a conference I was at, where Joseph Harvey, a lawyer who appears before your court a lot, said the Canadian Supreme Court was the most progressive in the world because of the way it interprets the Charter, because of some of the groundbreaking decisions, nation-changing decisions it has made, and I would say mostly assisted death in the past couple of years, has really changed everyone's life, because everyone has to deal with that or think about it at one time or another. Would you agree with that, with the idea of it being the most progressive in the world?
I would say so, yeah. And I must say I'm very proud of that. And you refer to certain areas of our society, like health issues and that type of issues, but we can also say the same thing in terms of other issues like democracy, like the rule of law. I spoke about it a few minutes ago, but the respect for institution. And when I'm called to travel and make speeches outside Canada, in Europe, for instance, people are very much surprised to see how we operate. And I'd like the people of Canada and my own province, Quebec, as well, to know about that more, because we are unique in terms of legal system. We've got the civil law, the common law, which are the two largest type of law in the world. We have a court which is bilingual. We do it in both official languages, and we have a Charter of Rights. And we were able to interpret that charter along the way, given the evolution of society. So many nations across the world look at us, look at our jurisprudence. I know for a fact that there are Supreme Courts elsewhere in the world who will refer to our jurisprudence, because we were able somehow to deal with all of those issues. And I think that given the environment now that we see for the last couple of years, I think that Canada and the courts will play a much important role on the international scene, and for the benefit of all Canadians, I would say.
Okay, next one on the list here is Kevin Gallagher from CTV.
Chief Justice, I actually would like to follow up on one of the questions asked earlier in French. Just the notion of these pending jurisdictional challenges for environment. But I just want to feel from you, and I think I might get a sense already, but with the changes in the environmental risks, such as climate change and other issues like that, does the Charter adequately deal with the shared jurisdiction in some matters for provincial and federal? Is there enough within the current legal framework for legal minds across Canada to deal with these upcoming jurisdictional environmental issues from provincial to federal?
I'm very anxious to discover that and to find out for myself as well. That will depend on the nature of the legal problem and the way it will be presented and the evidence. So let's wait and see. But it will come, and I'm looking forward to it. Thank you very much.
Great, thank you very
Merci
much.
beaucoup.
Come again.
I will.
Thanks, thank you. After you, sir.